All right, everybody, welcome back. I'm Eric Finch. This is a Boundless immigration Q&A with a former USCIS officer. I just want to remind everybody that I am not an attorney. I am a former USCIS and DOS consular officer, and we're here to talk today about the immigration system, questions people have, visas, whatever else that people are interested in that relates to immigration. But this is just a chat where we share personal opinions and general information, and it's designed to give people a little bit more insight into how the system works and what kind of options they might have before they seek the advice of a immigration legal professional for their specific case. Okay, so with that out of the way, just want to say thanks again to everybody who's come back to see us. I love these conversations, and we always learn so much from each other. I have a number of questions today that we'll go over, and I'll try to give my best sense of guidance and offer any insight that I have from my experience. While we are answering these questions, feel free to submit additional questions in the chat. One of my colleagues here at Boundless will record those questions, and with the time that we have, we'll try to get to as many of them as we can. All right, just want to remind everybody we do this once every 2 or 3 weeks. So, excuse me there. And we will have a chance to do this again for any questions that we miss. And thank you very much for your submissions. And like I said, if I miss anybody, it's just because we ran out of time. We're trying to do these as fast as we can in the order that we get them, okay? All right, so let us begin. First question that we got this week is, why did I get an RFE for documents that I already sent? Common question. Very frustrating for a lot of folks in the immigration system, and also very frustrating for a lot of immigration attorneys who assist people with this process and receive payment from applicants to ensure that they have the most complete application possible. And then attorneys are frequently embarrassed when the packet that they put together and submitted to USCIS leads to an RFE, when both the attorney and, in most cases, the applicant know that those documents were included in the original packet. Now, I'm going to do a little bit of a devil's advocate here, because, I was at USCIS. I handled many of these cases. And I can tell you that, a lot of this stuff is being handled on paper by human beings. And like all human beings, they make mistakes. Sometimes they miss things. Some of these files are hundreds, if not thousands of pages long. It can be very difficult sometimes to find a specific document that they're looking for. And, it does happen that in some cases there's items in there. Perhaps they were put in an unusual order. Perhaps the file is a bit unorganized due to earlier processing steps. And it is possible that they will miss something that you did submit and requested. And in that case, the best thing you can do, give it to them again. Because if they make a request specifically for that document and you send them that specific document and request to an RFE, problem solved. Okay, so I know it doesn't feel great that the case is delayed and that you're being asked for things that maybe you submitted before, but that's just one of the imperfections that we have to deal with in a system like this that's paper-based, that involves like multiple steps in the process, that has many people looking at things. Some of the new online filing methods that USCIS is providing, I think, will help to improve that situation, because they will actually give you an opportunity to submit documents online through your USCIS account. This is already possible for N400 naturalization applications, for example. And in that case, again, having worked with that interface, I can say that it's much more straightforward. You ask for something, you receive something. It's easily bucketed in the RFE, next to the RFE request, where they can identify what was sent in response. And then usually you don't have that problem with some of the newer filing methods. But yeah, for as long as people are dealing with paper files, for as long as people are dealing with hundreds of pages of supporting evidence, there is a possibility that something will get missed. The adjudicators obviously have a lot of time pressure to move quickly through these applications. And if they can't find something, then it's a lot easier for them to just go ahead and fire off an RFE requesting it than, go through the file 3, 4, 5 more times just to make sure that they didn't miss it somewhere in between a bunch of other paperwork. So, I agree, not the greatest system. Doesn't feel great. Doesn't feel great for an attorney to have the applicant then turn around and say, hey, I thought you had this covered and you submitted this for me. It causes a lot of frustration, but that opportunity to fix that problem through the RFE is really your best option to address that. And if you can get that back to them as soon as possible, then, you can move on with your case and, processing, right? Okay. So next up we have, there was a question here, when is the interview date? When would the likely interview date be after applying for asylum in December of 2021? Well, if you applied for asylum in December 2021, I have some bad news for you. You're probably going to be waiting 5 to 10 years, according to current wait times, adjusted for the actual area where you are currently living. Okay, because there's districts, right, and there's different immigration courts, and they're going to have their own backlogs and dockets, right? And you're going to have to get in line between every person who came in front of you. There's some exceptions; it doesn't always go like in perfect order, but yeah, the wait times for asylum interviews are so long that what I frequently saw with folks who were younger is, they would be intake through the asylum process, and then, they would, hopefully if they were processed correctly and they, it was an affirmative asylum claim, they receive work authorization, things like that, parole, they have an I-94, and then you just get on with your life because that asylum interview may be a decade from now. And in between that, many people find other ways to adjust status. Younger folks can get married or meet somebody and do a family-based immigration process, again, assuming that they had that lawful entry, right? They were inspected and admitted by CBP. We saw that frequently, and in which case, if you get your green card through some other method, usually they'll just close the asylum case because it's kind of a moot point at that point, right? There are some areas where, getting the asylum claim processed and receiving your green card that way, could be slightly more beneficial. I mean, there's certain programs that you would be eligible for, the conditions under which you can adjust, and the things that you can get excused in terms of ineligibilities are a little different. So, yeah, if it does come to a point where you have to choose between one process or the other, it's definitely worth talking to an immigration legal professional to understand the pros and cons. But for most people, what it comes down to is I can do my green card now because I married an American citizen, or I married an LPR, or I have some other, qualifying relative who can file a petition for me, or wait 8, 9, 10 more years to see what happens in asylum court, which is kind of an uncertain outcome, right? We don't know what the decision of that court is going to be on your specific claim. Most people will go for the quicker and the more sure thing and go ahead and get it done another way. Now, there are a lot of folks who, because of their age or circumstances or family situation, are not going to have those other options, and they're going to have to wait for that outcome. But yeah, the asylum system is deeply flawed right now, and it's not working very well for folks. It's not creating opportunities for people to get their claims adjudicated in a timely fashion. So you can look forward to long waits there, and it can be a very nerve-wracking and arduous process. So I'm not, unfortunately, a refugee and asylum expert, so I can't really get into more detail than that on this specific question. But there are a number of people out there who do work in the nonprofit space, in the pro bono legal representation space. There's a lot of people across America who care a lot about asylees and refugees and want those programs to work better. And that is a conversation that's going on at USCIS. How can we improve that? How can we improve the funding for that? How can we make it more punctual for people? How can we put more authority in the hands of USCIS adjudicators to make adjudications and things in a more expedited manner? How can we make it more flexible for people who, under certain circumstances entered the U.S., giving them more flexibility where they can get their claims adjudicated? So the general trajectory seems to be in a positive direction finally, after a lot was done in previous years to sort of undermine the functionality of the system, but also the backlogs and the pressure is unprecedented. There's new people flowing into the asylum system every day. I think it's something that you have to pay close attention to, and we'll continue to talk about here on the Q&A with folks when they have questions. And any new positive news that I have about the asylum process, I'll be happy to share that. So we'll keep our ear to the ground and see what happens. Okay, next there's a question specifically about Morocco, and I guess that would be U.S. Embassy Casablanca. Is it hard for Moroccans to get tourist visas or work visas? Because this is kind of a general conversation event, I don't like to dwell too much on specific nationalities and things. I think currently in Casablanca, it takes about 3-4 months to get a tourist visa interview. I think student visa interviews, like most places, are a bit shorter wait. So that's good news for students coming from Morocco. You should be able to get in and out of the embassy within a few weeks if you need to. That's all subject to change, of course. Now, if the question is more about, is it hard? I don't have direct experience working in North Africa. I don't know what their refusal rates were or have been. I think generally it's going to be a little bit challenging in some countries like those in North Africa to get a tourist visa. But the normal criteria would apply, right? You got to show ties to your home country. You got to overcome the presumption of immigrant intent. You got to show that you have the financial wherewithal to fund your trip or your planned travel. And then you're going to have to show that you have ties to your home country, which for most people means, does your socioeconomic status in that country make sense for a person who would be a world traveler or who would be traveling to the U.S. for tourism or business, things like that. So you would want to talk about them. You would want to talk about that with the officer at your interview there. And yeah, I'm happy to talk about general NIV interviewing tips and things like that if that's of interest. It's something that we've done a lot of work to understand over here at Boundless, and we're trying to figure out a way that we can help people understand that process a little better. So more news to come on that in the future. Okay, let's do one more that was submitted in advance, and then I see a few others coming in here. This question about DACA. Do you ever feel like DACA will be out of a ban for new applicants? I have followed the DACA program very closely since its inception about a decade ago during the Obama administration. And this one's been very frustrating for me because, I've always supported a pathway to legal status and citizenship for the group of children who grow up in the United States, sometimes called Dreamers, sometimes called DACA applicants. It's always felt deeply unfair to me that folks who arrived here, had no choice in the matter, grew up here, spent time in the U.S. system, learned our culture, language, and background, who want to be part of the United States, because of the decisions that they didn't have they weren't involved in. They've been stuck in this sort of status that there's no way out of. So when DACA came, I was very excited. I thought, okay, well, this is the beginning, right? We'll give them, some kind of like pathway. A status that they can obtain that will ease the immediate pain and give them an opportunity to work and things like that. And then, under certain circumstances, that legislation can be passed that will give them, some requirements probably. I mean, it's not going to be free, and there'll be forms to file and things like everything else in the immigration system. But over a long enough timeline, those folks should be able to figure out a way to remain in the United States legally and pursue the opportunities that American citizens can pursue, right? Get involved in our democratic process, have a voice in elections, become a part of the workforce, be able to obtain professional certifications, chase their dream jobs, travel abroad without dealing with the hassle of like passports and visas and all the complications that come from being in an undocumented status. So that was my hope. And, it's been a bit of a roller coaster since then, right? Because, we've come so close a couple times. I mean, I won't go into individual legislative battles or times, but, the general, I think, with maybe a year or two exception, members of Congress have floated a sort of pathway to citizenship type option in one form or another in every Congress since DACA was enacted, meaning that there was legislation that was proposed. Now, it didn't fail to get enough support across the U.S. Congress to go into law. That's unfortunate. Different presidents have expressed support for some of these measures. Different Congress people have been involved in these efforts. There's been conversations made between Congress people of both parties about what this might look like and what kind of concessions would be needed to make this possible. But it's, sort of like a feature of the U.S. immigration system in general that in the post 9/11 period, somehow execution is just never possible. We're never able to really close the deal on these changes that we know we all need to make, that have broad public support, that affect the lives in a very significant way of millions of Americans, and folks who grew up here and dreamers, and so I guess that's sort of a long way of saying that this administration in particular had made a lot of noise early on about not just DACA protections and improving life for dreamers, but also farm workers, agricultural workers, critical workers who carried a lot of the burden of keeping the service sector and agricultural sector afloat during the pandemic. There was a lot of momentum there, I felt early on, and it's been very depressing to me to see that momentum sort of slowly disappear as we get into this midterm period. And immigration, yes, it's a thorny political issue in the United States. But again, these groups, these segments, these laws are ones that have always enjoyed a significant amount of public support and feel relatively uncontroversial. So it's very disappointing to see that we haven't been able to reach a political solution here. And, the DACA program is a great example. This question points out that, like, yes, DACA exists, and some number of people who, were eligible under the original guidelines of the program still enjoy that DACA protection. But it has been closed to new applicants for many years now, with a few very short periods where, because of court decisions and other things, it was allowed temporarily. So you have folks who got it early on, and a significant number of people are able to renew, but we haven't been able to, for a lot of folks who didn't qualify at that moment but now meet the qualifications, those people, haven't been able to apply to get it for the first time. And then when you consider that there was a time requirement, both time you've lived here and a certain period in which you had to have been in the U.S. up to a certain date, which was in 2012, large numbers of people, again, this was 10 years ago, there's large numbers of people who would sort of basically meet the requirements for DACA, who are younger or who came to the U.S. at a different point, who just don't qualify based on the existing requirements. And this is all a problem because, because this change was enacted by executive order, it's been subject to a lot of court challenges, and it's very difficult for the USCIS to translate into a set final policy, because it can be changed at any time. President Trump at one point attempted to sort of scale back this entire program, and that was also blocked by a court, mostly due to administrative procedure issues. And at the time, the court declined to rule on the overall sort of legality of the program itself, which leaves that as an open legal question. So, at different points, people who are paying close attention to this program have expressed that, yes, this program, in order for it to work the way it was intended to work, needs to be ensconced into U.S. law. It needs to be made into a law. So that is the thing that Congress needs to do. They have to act. And of course, the president, has expressed support, and of course, the administration would support that. But, it's really got to be something that we got to break through that congressional gridlock and make a decision about what we want to do with this group of people, which is hundreds of thousands of people strong. And, it really, like I said, if you were somebody who was interested in this, needs this avenue to get regular status in the U.S., you've been standing on eggshells for 10 years waiting for a final decision on whether this program is going to continue to exist, whether you can use the program, whether your children possibly could use the program. So it's really an urgent need. And I think, I just wanted to take this opportunity to express that, for me personally, that this is an issue that I feel is very important. And, I've done everything I can to support folks and educate people on how important this issue is. And I hope all the folks that are helping us participate and who are in this Boundless community can also, share our values here and do what we can to promote this and make sure that our legislators and representatives understand there's a strong need here. And it's really hard for people when we keep asking them to wait year after year after year for some kind of solution. All right. So kind of stay there for now. Let's do a couple that came in more recently. There's a question about the removal of conditions, the I-751 filing. So the question is, what is the process amendment if someone gets divorced with an already submitted joint I-751 filing? So I don't want to veer into the category of here's what you should do in your specific case with this. I'll just kind of talk about generally how divorces are looked at in the removal of conditions process. Now, there is a difference between a divorce that occurs before the filing of the form, in which case you do actually indicate on the form that you were divorced. And then there's the divorce that happens in the interim when it's processing, right? Like everything with USCIS, if you file a removal of conditions form, it's going to take 7-8 months in a lot of cases to process. And that's, especially for a relatively new marriage, there's a lot that can happen in a year, right? Things fall apart, people grow apart, new opportunities and jobs and things present themselves, and that sometimes that causes a rift in relationships. So it does happen, right? So let's talk about the two scenarios. So in the first scenario, I should also mention that in the past, a larger percentage of removal of conditions, I-751 petitions, or not petitions, but applications that were filed, did result in an interview. In a lot of cases in that interview, the expectation, if you were still married, was that the original petitioner and the beneficiary would appear for that interview. And if they did, and, especially if they already had children and, there's still ample evidence that they were in a relationship, that's a very simple adjudication, right? It's everything looks good. No issues. Let's go ahead and approve that. And I think for a lot of those folks, they've moved to a model that's more around interview waiver, right? Where it's if you're still married, if the evidence that you submitted on paper, like joint tax filings and bank records and joint lease agreements for apartments or property, that if that's all in place, then yeah, you're going to be in a situation where they're going to be inclined to go ahead and say, hey, do we really need an interview here? Like, let's just go ahead and push this through. Like, we don't have anything to worry about. And let's save time and focus on the ones that we are more worried about. Now, traditionally, when I say the things that we are more worried about, that is actually about folks who are getting divorced, right? Because the purpose of this removal of conditions form is to kind of like have a little look back to see, hey, like sometimes it's kind of hard to suss out if somebody's in a fraudulent relationship when they've only been married for a few months or, a very short period of time, right? And, if they have concerns along that, obviously they can cause delays and a potential denial for the original adjustment filing or the original immigrant visa filing. But if it doesn't quite rise to that level, then perhaps they're going to take another chance at the 2-year mark and say, okay, well, let's kind of see how this went. Now, I should also caveat that by saying it's not automatically disqualifying if you get a divorce, both before or after filing the form. USCIS understands that time passes and that folks grow apart, as I said, but they are going to want to have a conversation about it in a lot of cases, right? And they're going to talk to you and say, okay, well, can you tell me what happened? Because what they want to figure out is, was this a bona fide relationship at the beginning? Meaning, was this actually a real marriage that, unfortunately encountered trouble? Or was this an agreement between these two folks to commit immigration fraud, at which point, after receiving the benefit, they went their separate ways and hoped that nobody would be able to kind of see what happened to them afterwards. So that is kind of the purpose of that interview. And if you submit an application, I don't know what their internal criteria now are for interview waiver and things. I would suspect that folks who got divorced in the conditional period, which is the 2-year period after the conditional green card was issued, will probably, in a lot of cases, be asked to still appear for an interview. And it's understood that in most cases that interview would involve just the beneficiary because, yes, again, the petitioner you've divorced is illegal. And it's, again, this is a legal divorce. This is not separation. This is not we're living apart while we figure things out. If you have a legal divorce, you're going to indicate that. And then you're going to, appear for your interview. And I did a few of these interviews, and a lot of it's perfectly understandable. Somebody would come in, sometimes male, sometimes female, and they would say, look, here's what happened. This is, we got the green card, we moved, there was some issue. Sometimes there's a little infidelity involved by one or the other party. Sometimes the pressures of a new life in the United States get to people and they're not successful, and that puts strain on their relationship. So yeah, any of those explanations are fine. And, we would just have a conversation, take some notes, in some cases give a statement. And, if it all appears legitimate, supported by evidence and things like that, sometimes they'll submit some affidavits from friends or family members who saw the relationship play out and can verify some of the different challenges that they faced. That's usually enough for people to say, okay, well, we're not worried about whether this was fraud. We're just going to go ahead and say this was, a relationship that didn't work out. We don't see any reason to kind of open an investigation or talk about, taking the revocation of the green card. So we'll go ahead and give you that 10-year green card, and then, you're off to do whatever you like for the rest of your time in the United States, right? Now, I should also say, though, and I think for the second scenario I mentioned, in the case where there's been a divorce post-filing of the form, then the same logic will apply, right? Like there were cases where people would show up who had been married when they filed the form, and they would show up for their actual interview for the I-751, and it would just be the beneficiary. And I'd say, okay, well, what's going on? And they say, oh, we got divorced a couple months ago, so it's just me. Sometimes people who were divorced would both come anyway, petition and beneficiary, because, if it was on amicable terms, the petitioner understands how delicate the immigration process can be. Sometimes they're still willing to help and say, okay, I'll be here. And that goes a long way too, right? If you're divorced, but your ex-spouse can show up for that interview and sort of corroborate what you're saying in terms of what happened with the relationship, yeah, that's going to matter, right? Like that helps, but it's a lot to ask, right? Sometimes it's very difficult to talk about those things after the fact. But yeah, in that case, yeah, it works the same way. We talk it through, make sure that the evidence and things support what you're saying. And in most cases, you probably won't have a major problem unless, again, you did actually commit fraud, which USCIS is quite good at sort of picking out through the questions and things that they ask and the items that they look at. Now, There was a couple of other scenarios that people asked me about in the past that I'll just mention. Now that interview waiver is more prevalent, there are some folks who will file truthfully indicating that they are still married, get divorced, and then, because the form and the evidence that they submitted that at that time still shows they're married, they will get interview waiver and approval of the removal of conditions without updating USCIS on the fact that they're divorced now. Now, I would never talk about this in the case of any individual, but, I think generally speaking, when it comes to adjudications, unless USCIS makes a proactive effort to ask for things or update things, then, they're going to use the information they have and make a decision at the point that they need to make the decision, right? So if you receive a 10-year green card out the back of that process without updating them that you were divorced 2 weeks ago, then, that's your green card, right? And, if that is the adjudication decision made by the agency, then I think you can kind of go forward with that being the outcome of that process. Now, whether, under certain circumstances and timeframes, you need to update USCIS that something has happened after you file. I mean, generally speaking with USCIS, unless they ask for updates and things, it's kind of understood that what you submit is what they're going to adjudicate based on, right? And that's not a hard and fast rule because, again, they have RFEs. They can ask for updates. Sometimes they ask for additional evidence at the interview and things like that. But, I wouldn't view it as a major problem if that is the outcome of that process and it's indicated that you're an interview waiver case and you get your green card, permanent green card that way. That being said, every situation is different. There's definitely some steps that you could take to, let the agency update or understand what's changing with your particular situation. So if you have doubts, I would definitely work with an immigration legal professional and get their opinion as it relates to the specifics of your case. Okay, we're doing pretty good on time. I got enough time for about 10 or 15 more minutes. So I will kind of go through here. Let's see what else came in here. There's a question here. If you're a Canadian permanent resident, what is the best way to move to the USA? I guess I would say, so this is probably a case where it's a foreign citizen who had a passport from another country besides the United States or Canada, comes to the, for whatever circumstances, job related, family related, obtains LPR status, what the equivalent of LPR status, which is probably different, slightly different in Canada, but similar process, and gets the equivalent of a U.S. green card in Canada as a permanent resident of Canada, but is not a citizen of Canada, and wants to move to the United States. I guess my short answer would be it doesn't really make a big difference. There's no special privileges extended to folks who have Canadian permanent residency. There's no, I think Canadian citizens obviously have travel privileges and things that are related to their nationality, but anybody who traveled to the United States as a Canadian permanent resident would be traveling under the auspices of their original passport and nationality, right? So if you're a Pakistani citizen who has a Canadian permanent residency, then you would still need a visa to travel to the United States and things, right? So there may be some exceptions to this, and I mean, there's a lot that goes on at the Canadian-U.S. border in terms of sort of working around things or, sort of making exceptions and stuff because they know that people have to travel frequently back and forth. But yeah, I would say it wouldn't really have a significant impact on how you would go through the U.S. process. You're still going to need some kind of family-based or employment-based visa to migrate, as a permanent resident permanently to the U.S. I mean, of course, there's other categories like asylees and refugees, but that's not usually going to apply to folks who are living in Canada. And you would need to kind of go through the same process that any other foreign citizen would to get a permanent residency. Now, again, for Canadian citizens and things like that, there's special clauses. They can travel to the U.S. across the northern border without a visa because of by using visa waiver program. Of course, Canadian citizens have access to the NAFTA visa, which allows them to work in the United States with a job contract without going through the labor certification process, things like that. So, I think if you're a Canadian PR and you have a path to Canadian citizenship, that might be something to explore if you're looking for ways to utilize some of the unique privileges that Canadians have as it relates to the U.S. immigration system. Okay, but as long as you're kind of primarily holding that foreign passport, I don't think the Canadian permanent residency is going to open a huge amount of special avenues or doors for you as far as it relates to U.S. immigration. Okay, let's go back to some of the ones. I do want to get through these ones that were submitted in advance. There's a question: does legally overstaying a B2 visa by filing for an extension, will that affect a K1 petition? So again, we have to keep in mind that these K1 fiancé visas are not status you can adjust to in the United States. You do have to actually obtain that visa overseas in order to travel into the United States. So I'm assuming that the person who's asking this question is now located overseas, because they would have to go ahead and get that K1 visa. But if that's the situation, so let's say somebody who came to the United States on February 2020 with a B1, B2 visa, received I-94 with 6 months of permission, duration of status in the U.S., as many people do when they arrive. And then because of the situation that we all know around COVID, made it incredibly difficult to travel, especially to specific countries for almost all of 2020 and really most of 2021. The person took the step of filing an I-539 extension of status request for their B2, in which cases usually an additional 6 months is granted, which would allow that person to stay until February 2021. And then again, based on the way this question is asked, I assume that they left within the amount of time that was granted in that extension, meaning that they did not overstay or accrue any unlawful presence, and then return to their country or some other country outside the U.S. No, that would not cause a problem in most cases with a K1 I-129F petition filing. Why? Because you didn't do anything wrong. You used your visa the way you were supposed to. You filed for an extension and it was granted the way that you were supposed to, and then you left on time. Yes, I mean, there may be some questions, right? They're going to say, "Oh, okay, what were you doing for all that time? Like, what was going on in the U.S.? Were you already spending time with your fiance? Did you have another fiance?" Like, that's all fair game, right? Like, they will ask questions about these prior periods of residence in the U.S., especially if you lived here for a year almost, right? Now, there's a lot of good answers to those questions. Maybe you had a family member here, elderly parent who you wanted to take care of or something like that. That's all perfectly valid. But yeah, you would want to be able to be ready to discuss that with the adjudicator, or if you were submitting evidence, or with the consular officer at the embassy appointment. You want to be able to talk about that. Here's when I arrived. Here's when I left. Here's why we made the decision to ask for the extension. Here's what I was doing and how I was supporting myself during that time. Hopefully you weren't working or doing anything else that's not allowed under that B2 visa. But as long as you didn't violate the terms of the visa, then generally speaking, that kind of scenario is not going to lead to any problems or ineligibilities or inadmissibilities with your follow-on K1 petition. All right, let's do maybe one or two more. Let's see what else we have here. There's a question: does the processing time on the USCIS website include the NVC and embassy process for the K1? In a word, no, it does not. USCIS reports the amount of processing time for their own internal procedures and adjudications. They don't include anything that happens after it leaves their agency. So it's very important to remember, and this is something that we try to capture on our Boundless website when we do projections and things that we derive from some of our internal data. We're trying to really help people understand that, like, what you see on USCIS is not only not a definitive time frame, it is also not at all inclusive of the additional steps that happen overseas. So right now, and this was updated a few months ago, USCIS will list the processing time by form type and location, right? So I-129Fs, I haven't looked at the data in a little bit, but there's some good news there, right? Like the processing time for those I-129F petitions, which is the first step in the K1 visa process, has gone down. Prior to the pandemic, it was probably somewhere between 4 and 8 months in most cases, and it's about back to where it was after a big bump during the pandemic due to all the issues that we all know about, right? So that's good news, right? That means you're going to get that approval notice. You're going to hear from USCIS fairly quickly, and they're going to get that I-129F approved and sent over to the National Visa Center. Now remember, the National Visa Center is a Department of State facility, and it's a sorting facility where they do a lot of the prep work to get these K1 petitions ready for scheduling at a U.S. embassy. Now it's different from, say, a spousal immigrant visa, because in the spousal immigrant visa case, they handle a lot of the paperwork collection for your financial data and other stuff. at the NVC step, so that extends it a little bit. For the I-129F, you're probably not going to hear a lot from NVC during that step, aside from possibly assigning you a case number, because technically the K-1 is it involves a petition like an H-1B does, but it is a non-immigrant visa, also like an H-1B, right? So I know that's a little confusing because it does lead to green card status after you arrive and adjust status, but it's not handled it's not handled in a way similar to the way immigrant visas are handled at that particular step. So it'll go to the National Visa Center. And then, I think in the past with K-1s, people didn't think much about this because it was very quick. As soon as USCIS approved the item, they didn't have long backlogs or wait times at very few, if any, of the U.S. consulates and embassies overseas. So you would hear very quickly from the NVC or the immigrant visa unit at the embassy or consulate in the country of the beneficiary, because it would go there in a few short weeks. It would get scheduled. They would send out notifications and begin the prep work for the actual interview. So it felt like really all you were waiting on for the most part was USCIS. Now that has changed a lot post-COVID, during COVID and post-COVID. Now many of these embassies and consulates have significant backlogs of their own, and it varies by location. There's some out there that probably feel like they did before COVID, where it's a very low flow. There's not a lot of other activity in the immigrant visa unit, and they're able to pick these things up pretty quickly. But in a lot of the places that you can guess, like where they send a lot of folks to the U.S. on K-1 visas, Mexico would be an example, Philippines, Vietnam. It's really pretty spread out all over the world, but there's several countries where a fairly large number of these visas are processed. That can what's going on at that particular embassy can extend your time quite a bit, to the extent that I think some people are now waiting just as long for their embassy appointment after the NVC step as they did to get their petition approved in the first place. So yeah, I think you really have to factor in a significant amount of time now, and I think if you want to get a better sense of like how this will affect you directly, start paying attention, start talking to people, start looking for forum posts or discussions online on like our immigration on Reddit, in various forums. I know that a lot of the visa related or immigration related websites will talk about this. And if you can find a few folks that came from the country that your beneficiary is in, you may be able to get a little bit better idea of what this actually might look like in terms of months or days or weeks, right? So yeah, I don't have any specific data to share, but this is also something we're trying to pay attention to at Boundless by talking to our customers, so we can provide a little insight. If you're in the Philippines, it'd really be nice to know a little bit about what is going on in terms of backlogs and wait time in Manila, right? And the problem is USCIS is I'd like to see a lot more, but they do seem to make a strong effort to kind of be transparent about what's going on with their processing times. Department of State, they do talk about, and they post on their website information about non-immigrant visa wait times. They do not talk about immigrant visa wait times. They don't publish data. They don't publish wait times. So it's really something you have to keep your ear to the ground to try to understand and hear more about. So yeah, I would really recommend you do that. If you have an idea of where this visa interview might take place, start early, start reaching out to people, start talking to friends and family up there who've gone through the process, and just see what people are saying in terms of how long it took them after their actual petition was approved by USCIS. That should give you a better sense of what the additional time that will be. Okay. All right, we got time for one more, and then I'll wrap up. See, a couple new ones came in, so I'll try to handle some of these. Yeah, I'll take this an opportunity to kind of talk. There's a question: how long does the marriage-based green card process take inside the USA from a U.S. citizen spouse? So I know wait times is something that's been on my mind a lot lately, and there's so much data out there. There's so many conflicting information. It varies so much from field office to field office inside the U.S. or from embassy to consulate in each country outside the U.S. And a lot of people folks who come to Boundless for help. Our customers. Other folks out there in the immigration space, immigration attorneys. Everybody wants to know this information, right? You come to this process and you're like, and it's different for everybody, right? It depends where you're from, where you're at in the U.S., where your beneficiary is from, what country, what type of visa you're trying to get. It's a lot to untangle, and it's really easy for somebody to just tell you like, oh, hey, it's going to take this long, and you just go, okay, and then you wait and you wait and you wait and you realize, no, that's not how long it's going to take for me. That's how long it took for them. So this is something that we've tried to like kind of break out and help people understand better on our website. We do have several resources that we offer on our content that talk about this, that we update every month. And currently what we're saying for this, based on the USCIS data that we have access to, and the stuff that we're hearing from our internal customers, we're saying about 11 to 21 months all in for a domestic U.S. citizen adjustment of status, right? So this is a U.S. citizen petitioner with a spousal application for adjustment of status inside the U.S. Now, Eric, why is it telling me that 10-month range? Like, well, that's 11 to 21 months. Like, that's a huge difference, right? Well, you have to understand that inside the U.S., there's huge differences between the amount of time that it's taking to process these applications at each USCIS field office. There's some field offices that are doing it in 10 to 11 months, all in, start to finish, from the date that you receive your receipt notice after submitting the documents to the day that you get that USCIS case tracker is updated with approved status for your green card. And then there's other places in the United States and other field offices that are doing it in 29 months. Okay, so what the range that we provide is designed to capture the majority of people. We try to control for those outliers. Otherwise, you're always going to be hearing a very big number, because there are places that are taking a very long time to do this, and there's other places that are taking a relatively short time. And why is that? I mean, you got to remember, every field office has to be staffed. People have to be trained. People, the workloads vary. So USCIS has instituted some degree of workload balancing. So what they're trying to do is take these outliers that are taking a long time and some of these outliers that are taking a short time and try to help move cases around and process things to meet people in the middle. But you got to remember that there's very strict requirements on like where and when and how somebody applies for adjustment, and what field office handles it and how it's adjudicated. So, and people move, and, so you're somewhat constrained in that you don't get to choose. Like wherever you live, there's a field office that generally provides adjudicatory coverage for your area. And unless USCIS makes an internal decision to change that, you don't have the option to change it. You have to go where they tell you to go, right? So, I'll say up in like where I live up in the Pacific Northwest in Portland, they have basically 4 field offices up here. There's one in Spokane, Washington. There's one in Yakima, Washington. There's one in Seattle, Washington. And for all the whole state of Oregon, we only have a single one in Portland, right? So all of the people who live in Oregon have to come to Portland to get their adjustment interview completed. And, given the extremely large number of folks who are in, Western Washington, so that workload is balanced across a couple of different embassies. And sometimes this changes in how they divide it up. But so, you have folks who are in Southern Washington who have to come to Portland. That's unusual. But if we made everybody who lived around Seattle go to Seattle for their interview, it would take 3 years to get an adjustment interview, right? So these are the kind of things that USCIS is aware of. It's not great. Their hands are somewhat tied by the actual way that things are divided up in the U.S. But, there are some lucky folks out there who are in relatively low flow areas with, not a lot of folks coming through those field offices that are well staffed and, are mostly caught up. I think, a couple of years ago when I was at Portland, there were some people who came through for adjustment interviews for family-based green cards who had literally submitted their things 9 months ago, and that's how they got it that fast. I know that doesn't really impress anybody. Why does it still take 9 months? But that's quite fast for USCIS when it comes to that particular benefit. So good news is, this is something that I think USCIS is aware of. They are working very hard to bridge this gap. And if you have any doubts that they can do it, I would point to what they've done with N400s in the recent year or two, which is, they've taken the N400s, the naturalization interviews, also used to run, pretty a little faster, but used to run around the same processing time that the I-485 spousal adjustments did, right? 6, 8, 10 months. And I've heard from a lot of very happy people that, again, depending on your field office and when you file, that naturalization applications now, now they're filed online, processed online. They're handled at, field offices. And people are getting in like 3, 4, 5 months now for those. And that's incredible to me. So, let's all put our hands together and say congrats to USCIS for making a huge effort to bring that citizenship application processing time down. And let's cross our fingers and hope they can do the same for our green card folks and help them adjust and make that timeline quicker as well. So on that happy note, I will wrap up. Just say again that thank you everyone for joining us. I apologize for any questions we didn't get to. If you really want to get your question answered, please follow our social media accounts and things. They usually send out a request for questions in advance, and those are the questions that I like to focus on because we got to reward that engagement and preparation. So please get those questions in. Reach out to our folks. Make your voice heard, and I'll see you guys in a couple of weeks, and we'll pick it up from there. Just remind everybody again, I'm not an attorney. I'm here as a former U.S. government official sharing my insight and experience, and very happy to spend time chatting with you, learning more about our community and the questions that you guys have. And I'll see you again soon.